We have two witnesses here, and I'd like to keep moving here because I think the witnesses are showing great forbearance. Mr. Griffith.
I'll do my best, Mr. Chairman. I'm actually glad that the memos have come in. I do agree with some of the comments that have been made previously that staff was trying to get this thing in the right order so that you didn't have speculation and so forth going on. But I'm glad it's in because I want the press and the lawyers of the United States of America to take a look at this memo. When I first read this memo several weeks ago, I made comment on it then that it looked like a law school project. I even texted my staff and asked them if they could find out when Susan Richardson was admitted to the bar, because I believed it must have been only about 3 months before the memo was written. It turns out she was admitted in 1983, but that was a surprise to me because of the quality of work. There's no reference to court cases in this thing. It references one previous code section, doesn't give you any court cases on that code section that it says there's a distinction with, and then you get to the part where it says in here, once such a condition precedent, that being you can't subordinate, has been satisfied, paren or waived. There's nothing in the code that says they can waive. It has no continuing legal effect. In other words, as I said at the hearing when Mr. Silver admitted that he had not, sitting in the chair you're sitting in, Mr. Grippo, he had not even read the memo before putting the taxpayers of the United States in the back seat to the tune of $75 million. It was astounding to me that this memo was relied upon. I think it's great that the Department of Treasury at least threw up a warning signal in there somewhere and said, y'all better have justice look at this, because I frankly would like to see not only her asked to be here, but I'd like to see Susan Richardson subpoenaed to be here, because I want to find out exactly why she was putting a memo together like this. Was she told to come up with this? That's what I believe the very first time I read it. And what's interesting is on page 1 it says default, and this is what leads you to suspicion and speculation, because these are the series of things you've already heard about the footnotes from some of the others. Default on page 1. Well, the code also requires that if there's a default, the Attorney General be notified. Did that happen? Their own rules require in 609.18, if there's a deviation, Secretary of Treasury is supposed to consult with or notify. The DOE is supposed to notify the Secretary of Treasury. You know, I'd like to know if that actually happened, because this clearly was a deviation after a default. So they didn't follow their own rules. I don't know if they notified the Attorney General. It appears from the memos and the emails that we've got they didn't notify Treasury what was going on. And you know, it just seems like this entire memo. In fact, one of my original notes says it's inconvenient. Boo-hoo. And I think what happened here was Department of Energy made a bad loan. They realized they'd made a bad loan. They were trying to figure a way to cover up the fact, not that they'd done anything illegal, but cover up the fact they'd made a bad loan, and they went and broke the law. And with that, I'll yield to my colleague.
Balance of the time.